Okay, Mr. Glazer, are you ready to proceed with Mr. Baky?
Yes, Your Honor.
Okay, and Ms. Underwood, I have Keegan Ferguson here. Do you need a breakout session with him?
Yes, thank you.
Hello.
Mr. Ferguson, I'm going to put you in a breakout session with Ms. Underwood.
Okay, thank you.
Okay, so this is file 25-22396-FH, People versus Derek Mitchell Baky. We're here today for arraignment in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure for the people.
B.B. McClure, on behalf of the people.
John Glazer on behalf of Mr. Baky.
Okay, and does Mr. Baky wish to have his information read this morning, Mr. Glazer?
No, Your Honor, we'd waive the reading of the information, acknowledge receipt of that as well as the prosecutor's witness list. Does he have another file or is this just his only file in circuit court?
This is the only file I have on the docket today.
Okay.
It's the
don't know.
only file. I'm sorry. It
This
is
is
the only
the-
file I'm showing.
Okay. Yeah, Your
But
Honor,
he
we'd
does
ask-
have a John, he does have a
Misdemeanor.
misdemeanor probation file.
Yeah, okay. Your Honor, we're gonna enter a plea of not guilty at this time and ask for a pretrial. We'd ask to have it be set out for approximately 4 weeks. And I'm asking the court if he can be released to drug inpatient rehab. He has a similar condition down in district court that he can be released to rehab, inpatient rehab. But if he leaves or does not complete the program, the bond goes up to what did you say, Mr. Baky? 100,000?
Yes, sir. It was $100,000 cash surety that was issued by Judge Shadler and Judge Morgan as well.
Okay. Those are on violation of probation.
Yes, sir.
Okay, so he has that or agreement downstairs that he can be released, and if he can get that on this one up here, we would ask, we would try. The girl in our office would try to get him into an inpatient program. The other thing I was going to ask Your Honor, or advise Your Honor, is I'm going to try to have him screened for drug court too. That's why I need to put it out about 4 weeks, 5 weeks. I think it could take that long. It depends on when they meet.
Okay. So 4 weeks would be October 15th,
October 15th.
correct?
Okay, at 8:15.
Correct.
Okay.
And Ms. McClure, is there anything you'd like to say with respect to the bond request?
Only that in reviewing the notes, it does appear that the bond that was set in district court on this file did have that reflection of release to inpatient, but it did get set at 100,000 cash or surety.
If he leaves on or fails the program, is what he thinks.
Oh, okay. That's not what the notes had said on this file, but
Okay.
yeah. So I'm okay, Judge, with however you want to word that or do that.
Okay, so I will modify Mr. Baky's bond so that he can be released. Let me see, what is the bond? Bond right now is $10,000 cash or surety. I will modify that so that he can be released without posting that bond to a residential inpatient treatment facility. However, if he does not successfully complete that, that bond would come back into play and need to be posted if he's not, if he doesn't complete that.
Okay.
Is there anything else we need to address with this case today?
I don't think so. Mr. Baky, has anybody been trying to get you in, or do you want me to have the girl in our office try to get you into a program?
I got an idea of what I was trying to get into Harbor Hall.
Well, let me talk to our girl and then she'll talk to you, okay?
Yes, sir.
And we'll see if we can get you into an inpatient, all right?
Yes, sir.
And just for the record, as far as I know, the last I've been told, if someone is qualified for drug court and does go into that, that is part of the drug court program, as they would,
Yeah.
after sentencing, be released. So they'll find somewhere for him.
Yeah. The only question on his drug court is he does have a felonious assault. I don't know if that disqualifies it, but 10 years ago or something, but that is what it is. I'll still have him screened.
Okay, so Mr. Baky, you can let the officer with you know that you're done with court for today.
Yes, sir. Thank you.
Thank you. Okay, Ms. DeMont, are you ready to proceed with Ms. Flannery, or do you need a breakout session with her?
No, Your Honor, we're ready.
Okay, Ms. Flannery, if you're there, I need you to unmute your device, please.
Okay,
All right, and you are Heidi Lynn Flannery?
yes, sir.
Okay, so this is file 25-22353-FH, People versus Heidi Lynn Flannery. We are here today for a pretrial conference in this case. There's also a pending contempt of court from when the file is still in district court. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure on behalf of the people, and for the record, Miss Flannery also has a second file here in circuit court, ending in 5-4, so 2522354 FH, and
You are
that's
correct. Thank you.
up for pretrial today.
Yes, thank you. And Ms. DeMont.
Katerina Dumont for Miss Flannery.
Okay, and Ms. DeMont, where do we stand with Ms. Flannery's case?
Your Honor, this is our first pretrial. We waived up from district with an agreement that contains a significant amount of restitution. Miss Flannery has been in contact with me and is working on being able to obtain those funds, because the offer gets better as the amount she can pay towards restitution for sentencing purposes. So what we would ask, and I did speak with Ms. McClure, if that was okay with her, if we could have another pretrial about 30 days out to see if she can obtain more of those funds.
Okay, is that agreeable with people?
It is, Your Honor, and just for the, sorry, I have a sore throat today. For the record, the minimum we're asking for Miss Flannery to avail herself of the plea is at least $2,000 by sentencing, but I do agree to an adjournment to have her get around as much as she can.
Thank you.
Okay, so a month would be middle of October. I can do October 15th or the 22nd, whichever you prefer, Ms. Dumont. You are muted if you,
22nd, if possible.
22nd, so October 22nd at 8:15. And Ms. Dumont, would you do the stipulation and order for that adjournment?
Yes, Your Honor.
Is there anything else we need to address with this case today?
No.
Nothing on behalf of the people.
All right, so Ms. Flannery, your next date is October 22nd at 8:15. You can log in using all the same Zoom information that you used today.
Thank you, sir.
So you're all set. You can go ahead and log out.
Okay, thank you. I am sorry. Second at 8:15.
I just signed it. Francis. Okay, Ms. Underwood, are you ready to proceed with Mr. Ferguson?
Thank you, Your Honor. Yes.
Okay, give me just a second. Okay, this is file 23-21319-FH, People State of Michigan versus Keegan Preston Ferguson. We are here today for a hearing on a violation of probation, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Messer.
Good morning, Your Honor. Ashley Messer on behalf of the people.
Good morning, Your Honor. Rhonda, I'll do it on behalf of Mr. Ferguson this morning.
And where do we stand with Mr. Ferguson today?
Your Honor, Mr. Ferguson is working with an organization called The Brighter Way. It's an organization that helps find employment for people with criminal records, Your Honor. He's working with them. Mr. Ferguson understands that the court patience is limited. We would ask for one more adjournment in this matter for perhaps 30 days in time for Mr. Ferguson to find stable employment and get a payment in, Your Honor. At that time, if that hasn't happened, we would welcome the court setting a evidentiary hearing in this matter.
Judge, I would like to keep moving forward with this case. He's been on probation for over a year without a job. Last payment was in July of 2024. for $5.41. He does have, at the time of his initial sentencing, was sentenced to probation with 1 year suspended for a violation. So I don't know the reason we would need another adjournment at this point.
All right, Ms. Messer, is there anything you'd like to add?
Your Honor, I'll leave it to the court. I understand the agent's frustration with Mr. Ferguson, and he has not been paying that a dime for quite some time. So I understand. I leave it up to the court.
All right, I'll give him the 30 days, but I'm going to set it for a hearing after 30 days, not another pretrial. So Ms. Clark, can we have a violation of probation hearing date approximately 30 days out?
Yes, Judge.
We do Friday, October 17th at 1:30.
Thank you, Your Honor.
Thank
Does that
you.
date work?
It does.
Ms. Messer, does that date work for the people?
It does, Your Honor. I just want to confirm that it works with Agent Walsh.
Yes, it does. Thank you.
That was October 17th at 1:30. All right, Mr. Ferguson, then the next date is October 17th at 1:30 p.m. You need to be here in person for that hearing.
Yes, Your Honor.
Okay, you are all set. You can go ahead and log out for today.
Yes, Your Honor. Have a nice day.
Thank you, Your Honor.
Your Honor,
Yes.
would you mind if Ms. Messer and I went to Judge Enblum's court? I know we have two over there that we could probably do very quickly. If she.
Okay, that's fine.
Thank you.
Okay, let's see. Mr. Glazier, I believe I have Mr. Causy here in the courtroom. Mr. Causy, you come forward, and Mr. Glazier, do you need to speak to Mr. Causy first?
Yes, I do, Your Honor.
Okay, so Mr. Causy, if you'll step outside and just to your left, down the hallway a little bit, there's an iPad. Okay, one second, Mr. Causy.
Oh.
And Mr. Goldstein, I have Mr. Cadell here in the courtroom.
Yes, Your Honor.
Are you going to need to speak to him, or are you ready?
We're ready as soon as I can get my camera to work. It's not.
Don't worry, David. You have the face of a beautiful human, so we know that. Don't worry.
No, I have a voice that's very well known, Elias.
As Judge Coretti told me in Macomb County, I have the face for a radio job.
There we go.
Okay.
It's frozen right now, but I'm here.
All right, so this is file 25-22244-FH. People versus Deshawn Cadell. We're here today for a final pretrial in this case, and we're proceeding today partially in person and partially by video conference.
Judge, it should be
have
Mr. McCready.
Yeah,
Okay,
it's David McCready's case, Your Honor.
Mr. McCready, are you there?
Yes, yes, I am.
Okay. So can I have the
Yeah, we have a resolution, Your Honor.
Okay.
My client is going to attend.
Sorry, go ahead.
Your Honor, my client is going to tender a plea of guilty to count 2. In exchange for that, the people are going to dismiss count 1. And if there is a habitual notice filed, they're going to withdraw that. And we have a sentence agreement that the sentence in this matter, minimum sentence in this matter, will not exceed the bottom of the guidelines. And Mr. McCready and I have both done the guidelines, and we both agree that they are 0 to 17.
Okay. Is Mr. McCready, is that a complete and accurate statement of the plea agreement?
That's correct.
Has Mr. Cadell signed a advice of rights form?
He is not with me, Your Honor, but if the court has a form, they can present it to him and he can sign it. We've discussed his rights. Or I can get a form signed to the court within a day or two.
I can get him. Mr. Cadell, the bailiff's going to hand you an advice of rights form. Take whatever time you want to look that over, and if you're comfortable, go ahead and sign it. Mr. Goldstein, Mr. Cadell has 2 pending contempts. Do you know what he's going to do with those?
Your Honor, in all honesty, we did not discuss them. I didn't discuss it with Mr. McCready either. So I would, we can just put those over till the date of sentencing in this matter. Discuss them with Mr. Cadell in the meantime.
I will let you know that I have a letter in the file from Mr. Coast that advises that he's also missed drug tests on September 4, September 9, and September 11.
So, Mr. Cadell, part of your condition of this agreement is you've got to start testing.
Yes, I'll be at work from 5 to like.
If there's another missed test, I'm going to issue a warrant for your arrest.
Yes, sir.
You'll have to make arrangements with work, Mr. Cadell.
All right, Mr. Cadell, will you raise your hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Deshawn Cadell, is that correct?
Yes, sir.
Mr. Cadell, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1?
Count 2, Your Honor.
I'm sorry, count 2. I apologize. Delivery and manufacture of cocaine of less than 50 grams.
Yes.
Do you understand the maximum possible penalty for that offense is 20 years in prison and or a $25,000 fine?
Yes, sir.
Are you satisfied with Mr. Goldstein and the advice that he's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. McCready?
That is correct.
That's correct, Your Honor.
Is that also your understanding, Mr. Cadell?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cadell, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right? And you need to speak louder.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yeah.
How do you wish to plead then to the charge that on or about February 6, 2025 through March 5, 2025 that you did commit the offense of delivery or manufacture cocaine of less than 50 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cadell to plead guilty today?
No.
I am
No,
not.
Your Honor.
Mr. Cadell, other than as we've talked about on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating your bond conditions, violating any terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Goldstein, do you want to do the factual basis?
Okay, Mr. Cadell, on or about the 5th of March, 2025, were you in the city of Adrian, County of Lenawee?
Yes.
And did you have in your possession less than 50 grams of cocaine?
Yes.
Did you know it was cocaine?
Yes.
Did you have any permission or any license to possess that cocaine?
No.
Okay, was it your intention to give, sell, or share that cocaine with someone else other than yourself?
Yes.
Okay, I think that covers it, Your Honor.
Did he say yes? I didn't hear that.
I'm sorry, I didn't understand what you said, Mr. McCready.
I didn't hear him say yes.
He did.
Yes.
Okay, all right. Yes, I am satisfied then, yes.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Goldstein?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Cadell has had full knowledge of his rights and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll take the plea, we'll take the sentencing agreement under advisement. I will refer this matter to probation department for a pre-sentence investigation, and we'll set sentencing for October 17th at 8:15 a.m. Mr. Cadell, someone from the probation office is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, you please be truthful about this offense and about your background. I'd also like, since you have 3 missed tests, to have you, Mr. Coast, do you have time to test Mr. Cadell today?
Absolutely, Judge. I'll meet him out in the hallway and report back with the results.
So step out of the hallway, Mr. Coast will meet you out there and administer a test. After you do that, you're gonna have to go across the hall to probation. They'll have a packet of information for you to fill out and return to them for your pre-sentence investigation.
Yes, sir.
Thank you, Judge.
Judge, Mr. Causy.
Mr. Glazer, you ready to go with Mr. Causy?
Yes, I am, Your Honor.
John, do you need Mr. Bayonetto for that, or is it something I can fill in for?
He's just going to enter a plea with Heidi.
Okay.
Who's that, John?
He's going to enter a plea with Heidi, under Heidi.
Who?
This is Jonah Causy.
Thank you.
All right, this is file 25-22351-FH, people of the state of Michigan versus Jonah Brennan Lee Causy. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. This is Mr. Bayonet.
Unless Mr. Banetto's there, I can.
Yeah, he was in the waiting room.
I think, oh, okay.
Okay, so Mr. Banetto, we just called Mr. Causy's case, so if you want to put your appearance on the record, we can continue.
Thank you, Your Honor. Alex Bayanetto for the people.
John Glazier on behalf of defendant.
Okay, and Mr. Glazier, where do we stand with Mr. Causy's case?
Your Honor, my client's going to plead guilty to the charge under the Homes Youthful Trainee Act provision that I've advised him that if he completes his probation successfully, that it would go off his record. And obviously, if he fails at his probation or fails to complete the HIDA requirements, which means Homes Youthful Trainee Act, if he does not complete those, then he would have a felony in his record, and he understands that and is going to enter a plea, Your Honor.
Okay, is that complete and accurate statement of the agreement, Mr. Banetto?
It is, Your Honor. Yes, a plea agreement was sent to Mr. Glazier yesterday. I'm not sure if he's had time to review that and sign it or not, but yes, it is just a plea as charged, and if the defendant is eligible for HIDA, the people would recommend that.
Mr. Causy, would you raise your hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Jonah Brennan Lee Causy?
Yes, sir.
Mr. Causy, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one false report of a felony?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, sir.
Are you satisfied with Mr. Glazier and the advice that he's given?
Yes, sir.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that, other than as we've talked about it here today, is that correct, Mr. Banetto?
That's correct, Your Honor.
That's correct, Your Honor.
Is also your understanding, Mr. Causy? If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. And you also have the right to testify at the trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
Yes, sir.
You understand that you're giving those rights up?
Yes, sir.
I would also note that I have a signed advice of rights form that Mr. Causy signed earlier this morning. That is in the file. How do you wish to plead then, Mr. Causy, to the charge that on or about May 19, 2025 in Woodstock Township, Lenawee County, Michigan, that you did commit the offense of false report of felony? Has anybody made any threats or promises to you to induce you to plead guilty to that?
Yes, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here today, or that it was not your own choice to enter that plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than to induce Mr. Causy to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Causy, other than as we've talked about on the record today, has your attorney promised you any particular sentence or estimated what your sentence will be? If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order or pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty to?
Yes, sir.
Mr. Glazer, would you like to establish the factual basis?
Yeah, Mr. Causy, hold on a second. On May 19th of this year, you were here in Illinois County in the state of Michigan, is that correct?
Yes, sir.
And you had an incident that involved a van, is that correct?
Yes, sir.
And during that incident, the van backfired and you thought you were shot at, and so, but you shot back at the van, is that correct?
That's correct.
And, but when you reported this to the police, your report was false because you never indicated to them that you had shot back at the van, is that true?
No, it was, I had tripped on my BB gun inside and I told them that I had gotten hit from them.
That you what?
I got hit by them.
Oh, you got hit
No.
by, oh, that's correct. I forgot about that. Yeah. You had shot yourself or something in the leg with a BB gun and told them that you had been shot when in fact the van had not shot you. Is that correct?
Correct.
Shot at you.
Yes, that's correct.
Okay, sorry, I mixed up the facts. I think that suffices, Your Honor.
Mr. Urbano, are the people satisfied?
The only thing I would add, Mr. Causy, you knew that what you were reporting to the police was false when you made it to the police, correct?
Yes, the part that I had mentioned at the end, yes.
Okay. I'm satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Urbano?
Yes, Your Honor.
Mr. Glazer?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Causy has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in any of them other than as we've discussed it on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for October 23rd at 8:15 a.m. Mr. Causy, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. And if you will step directly across the hall into the probation office, they'll have a packet of information to give to you and they'll collect your contact info. Thank
you. Your Honor, I told you, I didn't tell you I had Gro. I had showed it as Anne Marie Anslin's court, but I guess it's your court.
Okay. I guess this is Judge Olsaber calling. Could we have Eric Cooper in a Zoom with me? Have a chance? Do you need to speak to Mr. Gro?
Is he in court or is he there by Zoom?
He's here in person.
Yeah, yeah, I need to speak with him.
Hey, Judge, can I join that breakout room with Mr. Gro and John for a second too?
Yeah. Mr. Gro, if you'll step outside, there's an iPad just outside the door to your left. And Sergio, I think. Oh, never mind. Okay, and the gentleman at the jail, you're Mr. Cooper?
Yes, sir.
Ms. White, Mr. Fry, do you need to speak to Mr. Cooper before we start that case?
No, Your Honor.
I don't, Your Honor.
Okay. All right, this is file 24-22084-FH and 25-22161-FH. People versus Eric Lee Cooper. We are here today for a pretrial in both of those cases. There are also motions in the 24-22084-FC case. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Good morning, Your Honor. May it please this honorable court, Cena Colbert White appearing on behalf of Mr. Cooper, who appears via Zoom, Judge.
Good morning, Your Honor. Brian Fry appearing for Eric Cooper in file 2522161-FH.
Okay, so where do we stand? I guess let me start with Ms. White in the 24 case. Where do we stand with Mr. Cooper's case today?
Your Honor, I've had an opportunity to speak at length with the prosecutor that's handling my case. Judge, 2 motions were filed. She and I spoke in great detail as early as yesterday regarding the motions. Judge, we're scheduled to meet in person on October the 13th at 1 o'clock. I understand that there's a case that's closely related to both my case and Mr. Fry's case that is scheduled for pretrial before Your Honor on November the 19th at 8:15. I am respectfully asking on behalf of Mr. Cooper regarding my case, if we can set this matter for pretrial on November the 19th at 8:15. I will meet with the prosecutor. We will compare files. I have in fact received some of the discovery, and we would like to sit down together. I think we have scheduled 8 hours, something close to that, where we will compare files, Your Honor.
Okay, and Mr. Fry, would you be making the same request in your case?
Yes, Your Honor. I'd be asking for another pretrial. In my case, it looks like there's been a request for November 19th in his other case. That would work for me as well. If the court wanted to keep these together, that would certainly make sense. When I looked at the ROA, it looks like the prosecutor back in July had maybe dismissed something in my case, but I was never served, so I'm not sure what that was, but I saw the ROA reflected a nollie from back in July, but whatever it was, I have not received that. So I definitely need to be provided with that so I know what's going on in my case.
Yeah, Judge, that we had added a delivery count to Mr. Fry's case, and I had talked about ultimately perhaps doing a motion to consolidate all charge counts against Mr. Cooper for trial. So I had dismissed that and reauthorized it in district court, but Attorney White and I have discussed just that delivery count, and we have a stipulation in order to add that to the pending 2024 case where she represents Mr. Cooper. So that count that was added, that last count that was added was nollied. It's going to be added to the 2024 case. And we have preliminary exam on the delivery causing death case, I think on November 10th. So even though we have a stipulation to add that delivery count, I'm going to wait till after the preliminary exam on November 10th to actually add that count, because we are going to seek to add the delivery causing death count to this file. And I don't want to just keep filing amended informations till we've legally sorted out everything that we may potentially be able to add, if that's okay with the court.
Okay. Yeah, I think that sounds fine. So then we will adjourn the pretrial in both cases to November 19th at 8:15. And Ms. White, would you be willing to do a stipulation in order for your case? And Mr. Fry, could you do one for your case?
I'm sorry, Your Honor, I didn't understand the court.
Could you do a stipulation in order for the adjournment to November 19th for your case?
Absolutely.
And Your Honor, I can for mine as well. Miss Arnold, could I sign your name with permission to that stipulation to adjourn?
Yes, and Ms. White, you can too.
Thank you.
Okay, is there anything else that we need to address with this case today then?
Nothing, Your Honor, nothing further. Is it possible to have a brief breakout room with Mr. Cooper after we've come off the record, Your Honor?
Yes, that is fine. Mr. Fry, do you want to be involved in that also?
Yeah, that's fine.
Okay, give me just 1 second to set that up.
Thank you.
Your Honor.
Yeah.
Mr. Gro, Darren never was put into the Zoom meeting.
Okay, let me set that up again. Sergio, could you step out and help Mr. Gro get his camera turned back on? Yes.
Is that working now?
Yeah, 1 second.
Okay.
Okay, Mr. Gro, you need to join the breakout session now.
Yes.
And of course.
Okay, Mr. Millar, what cases are you here for?
Your Honor, I have Patrick Stevens, Dustin Gearhart, Dwan Harris, Monica Schultz, and Robert, someone that I don't have his last name.
Okay, Ms. Schultz is here in the courtroom. Are you going to need to speak to her?
Yes.
All right, our iPad's being used right now, so when that becomes available, we'll do that. How about Mr. Gearhart?
Yeah, I probably should talk to him too. It's Robert Morris I have, Judge.
Okay. Mr. Gearhart, we'll put you in a breakout room with Mr. Malero. If you give me just a moment.
Yeah. So pass your cup of water down the line to 20 people, but when it gets to the end, it's empty. That's not how you.
Okay, sorry, Mr. Fry, did I interrupt that breakout room earlier, or are you done?
Anything else you wanted to discuss, Mr. Cooper?
No, we're good. Thank you, man.
Okay.
Okay,
Thank you, Your
Mr.
Honor.
Cooper, you can let the officer with you know that you're done with court.
Yes, sir.
Thank you.
Thank you.
Mr. Mawad, are you ready to proceed with Mr. Knight?
I am, Judge. I am. I just switched to my iPhone. That's why I went off and came back on. But yes, I am.
Okay. Okay, so this is file 25-22188-FH, People versus Harold Leroy Knight. We are here today for a pretrial hearing in that case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Your Honor, Elias Muwad appearing on behalf of Mr. Knight.
Okay, and Mr. Mawad, where do we stand with Mr. Knight's case today?
So, Judge, there was an offer made by Mr. Sneed, a final offer. Mr. Knight has submitted to me some letters he would like Mr. Sneed to see if his mind would be changed. This case is not going to trial. This is a case where the proofs are pretty damaging to Mr. Knight. He knows that, but I'd like to have one more adjournment. And if the case is getting too old and you need to set it for trial, I understand. But submit those documents that Mr. Knight would like me to submit to Mr. Sneed.
Okay, I can adjourn it to October 8th. But at that time, if it hasn't resolved, that I'd be setting it for trial at that point.
More than fair, Judge. I will get something out to Mr. Sneed by the end of this week, and I'm sure we can have a final say on this early next week and then resolve the matter on the 8th.
Okay, and I apologize, Ms. McClure, I didn't give you an opportunity for any input if you had it.
Nothing on behalf of the people, thank you.
Okay. So we'll adjourn it to October 8th.
Thank you, Judge. I'll do a stipulated order. And Phoebe, can I sign your name to it?
Yes, you can.
Okay.
Okay, so Mr. Knight, your next date is October 8th at 8:15, and you'll log in using all the same Zoom information that you used today.
Thank you, Your Honor. Thank you, Judge.
Thank you.
Okay.
Mr. Knight, you go ahead and log out. Okay, Mr. Glazer, you ready to proceed with Mr. Gro?
Yes, Your Honor.
Mr. Gro, you can come forward. This is file 25-22330-FH, People versus Richard James Gro Jr. We are here today for a pretrial hearing in this case. There are also 2 pending contempts for bond violations.
Your Honor, I don't have a copy of the second one. I just talked to Darren about it again, but I guess what is that one for? Is that a positive or for not testing?
The most recent one is for a positive drug test on September 11th, which was positive for ecstasy. I'm sorry, the most recent one says there was a failed drug test on September 11th. And then it says the defendant tested positive for methamphetamine and ecstasy on September 15th.
Okay. So 9/4 and 9/11 were the dates of the tests.
No, 9/11 and 9/15.
Well, I mean, the first one was 9/4 though.
Yeah, he previously tested positive on the 3rd and the 4th, and the most recent, he tested positive on the 11th and the 15th.
Okay. Your Honor.
And Judge, I'm sorry to interrupt, but on the 11th, he failed to test. He did not test positive on the 11th.
I'm sorry.
He was positive on the 15th.
Yeah, I'm sorry, I misread that. So it's not a positive test on the 11th, it's a failed test, and then a positive test on the 15th.
Okay. All right, I got it. Your Honor, I'd like to set this. Are we doing a pretrial on the underlying charge too?
Yes.
Okay. I'd ask to maybe set this pretrial out a couple of weeks. I want to go over with Mr. Gro what's going on with those 2 cases. And I'd also like to do the contempt of courts at that same time. Mr. Gro has some serious health problems, takes a ton of medication. He's going to come in and see me, bring me in a list of those medications, and I want to see if any of those could be resulting in positive tests. I don't have the list, but I don't know. He takes like 15 different medications or something. He's going to come in and see me before we come back, and I'll be able to look at the list that he brings me.
And Richard, I need a hard copy of all your medications today from you.
I think he said he's got them down in the car. You got all your meds down in the car?
No, I got the hospital paperwork from when I got released, but I can get the medication for you. I sent it to you on your phone, but apparently you didn't get it.
Okay, so you need to, wherever they are, you need to get a list of all of your medications today, and you need to give those to Mr. Coast today.
I can go get them. Mom, just make a list or bring them all in.
Yeah, Richard, if you have a printout of your medications, I need something from a pharmacy or doctor, a list of all the medications you're currently taking.
Okay, well, I'm trying to ask you, do you want me to bring this list in, or do you want me to bring all my pill bottles in so you know what I'm taking?
Okay, I don't need the pill bottles. I need a hard copy of a list of the medications you're currently taking from a pharmacy or your doctor.
You understand?
Yeah, yes, I do.
All right.
So I can go down to CVS and have them make a copy of it?
They should be able to provide you with a copy of that, yeah.
And I'm going to need the same thing when you come in to see me.
Okay, no problem. I can get that done today then.
All right. And then you're going to come see me before the next court date. Come up and see me.
I'll call today and make an appointment.
All right. And when you're done here, you got to go down to district court.
Right.
Judge Shadler's.
All right, so I'm sorry, John, you wanted to adjourn the pretrial?
Just a couple of weeks.
Okay, so we can adjourn that to October 1st. Adjourn the pretrial to October 1st. And I'm sorry, again, Ms. McClure, did you have anything that you wanted to address?
No, thank you.
So within the pretrial, as well as all of the contempts to October 1st, I will enter a not guilty plea for Mr. Gro on the most recent bench warrant and issue a personal recognizance bond on that.
Is that at 8:30 or 8:15? Or not, maybe it's 9.
8:15.
Okay.
All right, so Mr. Gro, you need to get those lists to Mr. Post and Mr. Glazer.
I got I see my heart specialist on Wednesday next week. You want me to bring that paperwork in too for them?
I just want a list of your medications.
Okay.
And Mr. Gro, you set up an appointment to come in and see me before October 1st.
Okay, I'll call today and make an appointment.
All right, you go down to Judge Shadler's and we'll take care of that in about half an hour.
All right.
All right, thank you. Thank you, Your Honor. I think
Well,
that's
you're all
all I
set.
needed.
Yes, this is Judge Olsager calling. Could we have Dwan Harris, please? Thank you. Okay, Mr. Malero, are you ready to proceed with Mr. Gearhart?
I am, Your Honor.
This is file 25-22268-FH, People versus Dustin, Austin, Gearhart. We are here today for a pretrial conference. We also have 2 pending contempts, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, map the people.
Salvatore Malero on behalf of Dustin Gearhart.
And sir, you are Dustin Austin Gearhart?
Yes, sir.
Sir Malero, where are we with Mr. Gearhart's case today?
Gearhart has to adjourn the matter one additional time. It's my understanding Mr. Gearhart's testing, and I don't know the results, but I'd like to establish perhaps a good bench line before we work to seek a resolution here.
Ms. McClure, is there anything you would like to address?
No objection, Your Honor.
So the case is 123 days since bind over, so this is going to be the last adjournment, and I'm going to set it for trial at the next pretrial.
Thank you, Judge.
I'd also note I have a note in the file from Mr. Coast. It appears there was a recent positive test for amphetamines. If there are additional positive tests, we're going to initiate another violation. So, and I would say that given 2 pending contempts already, we would initiate that violation with a warrant rather than a show cause.
Judge, what's the date of that violation? Alleged violation?
We don't, so the alleged positive test was September 11th.
All right, thank you.
So I'll adjourn this then to October 15th at 8:15.
Thank you, Judge. Could I have another breakout with Mr. Gearhart, please?
Yes, can you do the stipulation in order?
Yes, I can do that, Judge.
Mr. Fry's thought. So, not that I wouldn't love to have.
Ms. Underwood, you have Mr. Kier.
Yes, I do, Your Honor.
Okay.
Judge, oh, sorry.
This is Judge Olsaver again. I've got another empty room. Could we have Timothy Kier in that one? Thank you very much.
I'm guessing Miss Underwood needs to speak with Mr. Kier one more time. If he is going to plead, I'll just need a few minutes to do an amended information and a plea form.
Okay.
So I just wanted to make sure the court knows, so.
Thank you, Ms. McClure. We were on the same page. I was just talking to you.
Okay.
Okay, Ms. Underwood, who else do you have then?
I have Paul Cherry, Lamont Simmons, Candy Ostrom.
Okay, Mr. Simmons is here in the courtroom. Do you need to speak to him?
Say you went to trial on all these files, many of them would stack, so you would serve sentence on what file?
Lamont Simmons is here in the courtroom. Ms. Underwood, do you need to speak to him?
Yes, I do.
Okay, Mr. Simmons, if you'll step out to the hallway, there's an iPad just to your left. Okay, so Mr. Simmons, go ahead and click join to the breakout room. Okay, Mr. Malero, do you need to speak to Mr. Harris?
Yeah, I should, Judge.
Let me know if you have any problems.
Okay, Mr. Simmons, you can come forward and sit at the table here. Okay, so, let's see, this is file 22-21164-FH, People versus Lamont Simmons. We are here today for a hearing on a violation of probation. We are proceeding today partially in person, partially by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Simmons this morning, Your Honor.
All right, where do we stand with Mr. Simmons?
Mr. Simmons is in the process of completing a class, Your Honor. We would ask for a 2-week adjournment in time for Mr. Simmons to get that done.
Well, this is the same thing I've heard at the last several pretrials on this. Mr. Simmons, this was a 24-month probation in which he did complete the class. And we're repeatedly coming back and saying he needs time to complete the class. So
If the court would like to set this for a hearing, that would be fine, Your Honor.
I'm just not inclined to continue kicking this out. It doesn't appear that there's been any progress.
Thank you.
So I'm going to set this for a hearing. Ms. Clark, can we have a 1-hour violation of probation hearing, please?
Thursday, October 2nd at 3:30.
That is not good for me, Your Honor. I'm sorry.
Friday, October 3rd at 9 a.m.
That would be better.
Sorry, at what time did you say that was, Ms. Clark?
9 a.m.
Thank you. All right, so Mr. Simmons, your next date is October 3rd at 9 a.m. Okay, great. Okay, Ms. Underwood, I'm going to move you to a breakout session with Mr. Kier then.
Thank you.
Okay, I'm sorry, Mr. Dagger Margosian, what case do you have?
Good morning. I have Brenda Nicholas, and I think Josh Coleman is for this morning in your court, but part of the information that I have is that it was in Judge Shaler, but I thought it's here.
No, I do have Mr. Coleman.
Okay.
Mike, I thought with Brenda that you were already her attorney once and it got conflicted out. So don't we need a different conflict attorney on the case?
I don't think it was conflict. I think she retained and then that has dissolved.
It was she conflicted out to Mr. Daly, and then when there was an issue with him taking the case,
That's not my understanding.
No?
I thought she hired Daly.
Okay.
I can look into it, but I thought she hired him.
Yeah, I just want to make sure because I do think we're on trial track and I want to make sure we don't run into any issues and have to delay any more.
Yep, I agree. I was
Okay.
going to ask for an, I don't know if I was going to ask for an adjournment anyway today because I don't have the prelim transcript and the police report, obviously, because we were just appointed. So
Okay.
that's what I was going to do. And Your Honor, I think she is in the waiting room.
She should be coming in right now.
Mhm.
Do you need to speak to Ms. Nicholas?
No, Your Honor, thank you.
Okay. Just flipping through the file, it looks like the appearance that Mr. Daly filed back in March indicated that he was retained and not appointed. So
Okay. Thank you for checking on that.
okay, so this is file 25-22170-FH, People versus Brenda Lee Nicholas. And we are here today for a pretrial hearing case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Ms. Nicholas.
Okay, and Mr. Dagger Margosian, where do we stand with Ms. Nicholas's case today?
Your Honor, procedurally, our office was recently appointed on this because prior counsel that had dissolved. And so I have been looking at this file, but I don't have the materials I need currently. I understand that there was a preliminary exam held in district court on this matter. So I'll obviously need the transcript of that. And I also need any police reports that are part of this investigation. So I would ask for an adjournment to get those items. And I understand that in speaking with Ms. McClure briefly off record, this case is on track for trial. So I don't want to mess up the timeline of that, but I do need to review these documents.
And Judge, the last time we were in court, the court acknowledged that the transcript was ordered in April. And as of the last pretrial on August 13th, we did not have that yet, and we still don't have it. And I thought Your Honor said you were going to have your office look into why it hasn't been received yet. So I don't know if you got any information on that or if it's something someone else needs to look into.
Okay, so we did have trials scheduled for October 15th, 16th, and 17th. Is that realistic right now?
No,
Or
Judge,
are
we
we-
vacated those dates when
we
Mr.
did.
Daly got
Okay.
off the case because that was a date we had with Mr. Daly.
Okay, yeah,
But I would like to get at the very least on the 2026 trial calendar if possible.
Okay. Have you filed something to vacate those dates? Because I don't have anything in the file about that yet.
No, I think we just did it on the record,
Okay.
but I can prepare an order if the court needs.
That's all right. So, let's set it then for a pretrial on October 15th. And I apologize, I don't have any additional information on the transcript right now, but I'll set this file aside and I'll follow up on that and see what's going on. Mr. Dagger Margosian, would you do a stipulation in order for the adjournment?
Yes, Your Honor.
And Mr. Dagger Margosian, I have a pretty lengthy file in this case. If it's anything you want to go over in person, you can come to my office and go over it with me if you'd like.
Well, that's fine. I would just ask for obviously any discovery to be replicated for our file as well.
Okay, so Ms. Nicholas, your next date for pretrial is October 15th at 8:15 a.m. and you can log in using all the same Zoom information that you used today.
Okay, thank you.
So you're all set, you can log out.
Okay, thank you.
Okay, Ms. Underwood, are we gonna need an amended information for Mr. Kier?
I just forwarded that to the court and Miss Underwood.
Okay, who did you email that to here, to Francis?
I included her on the email, yes.
Okay.
I'm printing them off right now and I'll bring them in the courtroom, Judge.
Okay, thank you. Okay, this is file 25-22274-FH, People of State of Michigan versus Timothy Allen Kier. We are here today for a pretrial conference in this case, as well as a pretrial and a contempt of court for failure to appear. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
I'll do it on behalf of Mr. Kier.
All right, and Ms. Underwood, where are we with Mr. Kier's case today?
Your Honor, we have, through negotiation, I believe, come up with an offer whereby Mr. Kier will plead guilty to an amended count of controlled substance under 25 grams, Your Honor, a 4-year felony, and there would be a killabrew in this matter to a 6-month jail term with credit for time served and no probation. And the methamphetamine charge, count 1, would be dismissed.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
Miss Underwood, did you put the sentence agreement on the record? Oh, okay, sorry. Then yes, that is accurate.
Okay. All right, Mr. Kier, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
And you are Timothy Allen Kier?
Yeah.
Mr. Kier, you can put your hand down if you want. You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, possession of cocaine, heroin, or another narcotic less than 25 grams?
Yeah.
Do you understand the maximum possible penalty for that offense up to 4 years in prison and or a $25,000 fine?
Yeah.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That's correct.
That's correct.
Is that also your understanding, Mr. Kier?
Yeah.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Kier, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yeah.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yeah.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yeah.
How do you wish to plead to the charge that on or about November 8, 2024 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of cocaine, heroin, or another narcotic of less than 25 grams?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
What?
Has anybody made
No.
any threats or?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than this plea bargain to induce Mr. Kier to plead guilty today?
None, Your Honor.
None, Your Honor.
Mr. Kier, other than as we've talked about it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Anything other than was spoken already.
I'm sorry, I couldn't understand what you said.
Not anything that wasn't spoken on the record already.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. Kier, on or about November 8th, 2024, were you in the city of Adrian, county of Lenawee, state of Michigan? Hello?
What? Yeah, sure.
Mr. Kier, the problem is I think that you're leaning forward and the microphone in the room is not catching your voice.
Yeah, I was in Adrian.
Thank you. And at that time, did you come into contact with Sergeant Adrian Robinson? And Sergeant Amador?
I did not, I didn't hear the answer.
Your Honor, Mr. Kier nodded. I think he needs to be reminded he does have to speak up and answer questions if he wants to avail himself of the plea.
I don't know who Sergeant Amador is.
Okay. Okay. Did you come in contact with the police?
Yes.
And at that time, did you possess a controlled substance less than 25 grams that was illegal to possess?
Yeah.
And you knew that it was illegal to possess?
Yeah.
I believe the factual basis is made, Your Honor.
I agree, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Underwood? All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Kier has had full knowledge of his rights. He's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for October 23rd at 8:15 a.m.
Given the sentence agreement in this case, Your Honor, does both the court and Ms. Underwood want to waive the PSI and do immediate sentencing?
I don't know. I don't have the jail credit to give him, and so I can't do that today.
Okay, no problem.
Thank you, Your Honor.
So October 23rd at 8:15 a.m. Here, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
So does that mean the PR bond's going to be lifted?
I don't think Mr. Kier has a cash bond, correct, Your Honor?
Well, at the moment, he's got a bond for the contempt of $50,000 for the failure to appear.
So am I on bond for that or no?
And he also has a bond. Oh, I'm sorry. So, yeah, so his bond right now is $50,000.
But I thought all of that was being ran concurrent.
We just want to make sure that Mr. Kier is getting credit, Your Honor.
Yeah, he'll have credit for it.
I'm not on bond right now for because I want to be getting credit for time served.
Yeah, you're getting credit. There's a bond, but it hasn't been posted, so you're getting credit for it every day.
All right.
All right, so you're all set, Mr. Kier. You can let them know that you're done with court for today.
All right.
Thank you, Your Honor.
Okay, Mr. Miller, are you ready to proceed with Mr. Harris?
Yes, Your Honor.
This is file 25-22314-FH versus Dwan Pfeiffer Harris. We are here today for a pretrial conference in this case. There's also a pending contempt of court for an alleged violation of bond conditions. First hand, the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Salvatore Miller on behalf of Dwan Harris.
And Mr. Miller, where do we stand with Mr. Harris's case today?
Judge, did you say we have a pretrial on something?
I think I misspoke. I think it's just the contempt.
Yeah, okay, good. I thought you were throwing me a curveball there. Your Honor, he's got cases scheduled for October 8th. We'd ask to adjourn this to that time. And then I'd like to ask the court to consider an argument on bond on this case.
Okay, so we'll set this over to October 8th. That October 8th is the pretrial that had already been scheduled. Okay, so what is it then that you want to address about bond?
Judge, just before, if I could, before Mr. Malaro addresses it, could I just say, this is Mr. Hartung's file, and bond was addressed at the last pretrial that Mr. Hartung was here for. So I would just ask that any bond arguments be put over until the October 8th pretrial when Mr. Hartung will be back.
Well, Judge, the bond's significant, and I think the court should hear my argument as this, whether Mr. Hartung's here or not.
So the bond changed because of a bench warrant, Ms. McClure. So I'm going to give Mr. Malaro an opportunity to address that.
Yeah, thank you, Your Honor. Judge, so it's been quite clear. Mr. Harris has several cases pending. And to update the court on that, we conducted a preliminary exam, and immediately afterwards, he was arrested on new charges, and they keep filing these new charges on Mr. Harris. Now, here's why I want to address bond, Judge. These allegations are very serious. There's allegations that he engaged in the sale of drugs, that they executed a search warrant and found drugs and guns in a home they claim he's a resident of. And that's 2 weeks ago. And they haven't filed any charges on that case. Nothing. Now, if they're that serious about it, they would have filed the charges. And what the state is doing is despicable to me. They're just literally hounding Mr. Harris, coming up with these allegations. And if he's this type of person, why would they not have filed these new charges if they're so credible? They haven't. And so, Judge, I'd ask the court to reduce this bond to $5,000 cash or surety, because clearly the state doesn't consider these charges that serious, or they would have filed these charges 2 weeks ago. Because I'll tell you why, Judge. They went and executed an arrest warrant on Mr. Harris when we were doing our preliminary exam before the exam ended so they could arrest him on new charges. And I, again, find that concerning to me that they're doing this to Mr. Harris. If they have all these charges, why are they just dribbling them out? Do them all at once instead of constantly dragging them back in the court for jail, to put them in jail so they can bleed them dry on bond charges. And that's exactly all they're doing. They're just punishing him. And you punish someone after they're convicted if they get a conviction, not before. So I'd ask the court to reduce the bond to $5,000 cash or surety. He always shows up for court. He's since I've represented him, he's always maintained contact with me. He's very serious about vigorously defending himself. And so I'd ask the court to reduce the bond to our request.
May I respond?
1 second.
See you all later.
All right, go ahead, Mr. Clerk.
Your Honor, I think just generally bond should be a reflection of the current charges that Mr. Harris is charged with. And I think reducing bond to 5,000 is a kind of a slap in the face to the charges that Mr. Harris is facing currently, that the 2 cases that he is charged with, they are very serious. And I think the fact that on the new file that was referenced by Mr. Milaro that hasn't been charged yet, I think that's a testament to how serious our office is taking this, because we want to make sure there's a full and complete investigation before we issue new charges. And that's exactly what's happening in this case. The investigation is still ongoing. In fact, I still see information coming in from the investigating agency as of this week. So we are waiting for the investigation to be complete before charges are issued. But again, the bond that's on Mr. Harris right now should be a reflection of the files that he is charged with and the charges that he's facing currently. The investigation that takes place on Mr. Harris is in relation to what the police suspect is criminal activity, not because someone is targeting Mr. Harris, as Mr. Milaro's indicated. It's not our office holding up Mr. Harris. It's again in relation to criminal activity that is suspected to have taken place. So I think it's a little insulting, the arguments that were put forth. Again, I just think the bond should be higher given the charges that he's facing, and I would ask the court to not lower bond, as it was already again addressed at the last pretrial, and I think it can wait to be addressed further with the prosecutor who has the intimate information of the facts of the case, rather than myself. But I do think, just my brief review of what Mr. Harris is facing, that bond should not be lowered.
All right, so in this case, Mr. Harris has been charged with two counts of delivery and manufacture of cocaine, heroin, and other narcotic, those being cocaine and fentanyl. Also a count of possession of analogs. Also a count of prisoner possessing contraband. In addition to that, he does have a habitual offender fourth offense notice. He has a prior conviction for felony firearm. Prior conviction for possession of methamphetamine or ecstasy, and a prior conviction for malicious destruction of fire police property. While on bond, Mr. Harris was arrested on September 4, 2025. The complaint for violation of bond conditions indicates that Mr. Harris was observed by law enforcement operating a motor vehicle and observed conducting a hand-to-hand narcotics sale. After that observation, Rhino obtained a search warrant and obtained some significant amounts of substances. I don't know what the status of the additional charges are, but that information is sufficient to give me a significant amount of concern that Mr. Harris is not complying with his bond conditions while he was on bond, and that he was engaging in additional criminal activity. And so that is why I set the bond where it is. I don't think it's an unreasonable amount of time that has passed for charges to not yet have been filed. If we get to the next pretrial and things have lingered, then I would probably reconsider. But at this point, I think that bond is appropriately set given the circumstances of which I am aware. So I'm going to deny the request.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, can I speak, please?
Mr. Harris, you're represented by an attorney. I don't know if he wants you to speak directly to the court or not.
He does not.
All right. You can let the officer with you know that you're done with court for today, then, Mr. Harris. Mr. Malero, do you need to speak to Ms. Schultz?
Judge, that's a Matt Murphy case. I'm just covering for him. I don't know what I don't know what's going on with it other than I'm covering for Matt.
So do you want to speak to her or no?
I would just ask, I don't need to, Judge. I would just ask to adjourn it. Looks from looking at the notes, looks like what's being asked of me.
Okay, so if that's going to be the case and someone's not going to appear, it would be appreciated if you, Mr. Murphy, or whoever's going to be missing, just contact the office and adjourn this without, Ms. Schultz has come to court today and waited patiently to have her case called, and we're not going to do anything.
Thank you.
All right, I mean, I can come over there right now, Judge, if the court would like.
When will Mr. Murphy be back?
Next week, Judge, comes back on Monday.
And if it helps, in district court, he did mention wanting to get her screened for recovery court. I don't know if that's something that can be set in motion while we're waiting for a pretrial with Mr. Murphy.
We didn't get a chance to discuss it.
All right, I'm sorry, Ms. Schultz, can you come forward?
Yeah.
So this is file 25-22361-FH, People versus Monica Lynn Schultz. We are here today for a pretrial conference, proceedings today partially by Zoom and partially by video conference. Can I have the attorneys place their appearances on the record?
Phoebe McClure, on behalf of the people.
Salvatore Malero on behalf of Monica Schultz, covering for Matt Murphy.
Okay, and we were discussing an adjournment, but Ms. McClure had mentioned getting, I'm sorry, did you say screened for treatment court?
Recovery court was what I was told.
Okay, and then Ms. Schultz, you started to say something about that.
Yeah, when I was on the phone with Matt Murphy 2 days ago, we never discussed that. He was trying to push for like a.
Okay, I don't want you to say much more than that.
I mean,
I want you to tell
that's
me
the first time I've heard of
what
anything
he
about
said.
that.
I'm just trying to understand how far I should try to set this out, because
Yeah, I have not heard anything about
if there's a potential for you getting screened, we're going to need a few weeks for that to happen.
Right.
So let me set this for October 15th, and I would maybe try to give Mr. Murphy a call when he's back in the office early next week, and you can maybe sort that out with him.
Okay.
Because if that is going to happen, it's usually a process that takes a few weeks.
Sure.
All right, so we'll adjourn it to October 15th at 8:15. Mr. Malero, could you do that stipulation in order?
Yes, Your Honor.
Okay. All right, Ms. Schultz, you're all set for today.
Thank you. Thank you, Your Honor.
Yes, Judge Olsafer again. Could I have Robert Morris and also Christina Sanford? Thank you very much. Okay, Ms. Underwood, do you need to speak to Paul Cherry?
No, I don't believe so, Your Honor.
Okay, this is file 22-20683-FH, People versus Paul Edward Cherry. We are here today for hearing on violation of probation, proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning, Your Honor.
And let me just make sure Mr. Cherry's there. Mr. Cherry, I'm going to send your request to unmute.
Yes, sir.
Okay. Ms. Underwood, where do we stand with Mr. Cherry's case today?
I don't know if the court has received confirmation from Mr. Cherry's Chapter 13 attorney yet, Your Honor. I tried to get a hold of your office briefly and just never got through. Can you tell me if the court has received anything from Mr. Cherry's Chapter?
I've not received anything that I'm aware of.
Okay. Then we would like another adjournment to see if I know Mr. Cherry's been in contact with them, so I don't know what the holdup is.
Well, who has he been in contact with?
With the attorney.
Yes, Mr. Cherry.
Yeah, I spoke to the attorney's office yesterday, and they sent me everything to show that they sent out the payment plan, the listing, all the paperwork was sent to the court.
To what court?
Your court. They're in Adrian.
Do you know when it was sent?
I could check the date, but I know it was several weeks ago.
I don't need any information about a payment plan. I just want to know that the bankruptcy has been filed, and to date, I have not received anything.
I will follow up. It shows that all those things were sent to you.
So if you have that, then take it to Ms. Underwood.
Okay. Yes, sir.
She will know where it needs to go.
Okay. Yes, sir.
Can we have just a brief adjournment for that to happen, Your Honor? That's better.
Gary here. Right in my face.
All right, so I'll adjourn this to October 1st at 8:15.
Okay, Mr. Cherry, bring me those documents.
Yes, ma'am.
If I don't have anything at that time, I'm just going to set it for a hearing.
Yes, sir. Thank you.
All right, you can go ahead and log out, Mr. Cherry. Okay, the gentleman's in jail. You're Mr. Coleman?
No, sir. My name is Robert Morris.
Robert Morris, I'm sorry. Mr. Malero, do you need a breakout session with Mr. Morris?
Sure.
All right, and Ms. Underwood, do you need a breakout session with Ms. Sanford?
I don't believe so, Your Honor.
Mr. Morris, there's something on their screen asking you to join a breakout session. Click
Yes,
yes or join, or whatever it's asking you to do.
I'm trying.
Okay, this is file 24-2.832-FH, People versus Christina Marie Sanford. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Ms. Underwood, you want to place your appearance on the record?
Ron Underwood for Ms. Sanford today, Your Honor.
All right. In addition to the probation violation, there's a failure to appear in contempt for failure to appear at the first violation probation hearing back on July 16th. Ms. Underwood, where do we stand with Ms. Sanford's case today?
Your Honor, I believe Ms. Sanford wishes to take responsibility in this matter and enter a plea.
Okay, for both the probation violation and the contempt?
Yes, Your Honor.
Okay. Ms. Sanford, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Christina Marie Sanford?
Yes, Your Honor.
You can put your hand down if you like. And Ms. Sanford, do you understand that you have the right to contest the violation of probation charge and to have a trial on that?
Yes, Your Honor.
You understand that you also have the right to contest the contempt for failure to appear charge and have a trial on that as well?
Yes, Your Honor.
Do you understand that throughout the trial you'd be presumed innocent until guilt is proven by a preponderance of evidence with respect to the violation of probation?
Yes, Your Honor.
And do you understand that with respect to the contempt for failing to appear, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have any order any witnesses you have for your defense to appear at your trial. You understand all of that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, do you understand that you have the right to testify if you wanted to testify?
Yes, Your Honor.
How do you plead to the charge that you violated the terms of your probation? By failing to submit to drug tests after you were released from jail?
I plead guilty.
And how do you plead to the charge that you committed contempt of court by failing to appear at the violation of probation hearing on July 16, 2025?
I plead guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Have you been threatened in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed in court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes.
So you were previously placed on probation in this case that required you to do drug testing, correct?
Yes, Your Honor.
And according to the request for probation violations, you failed to do your drug tests after you were released from jail. Is that right?
Yes, Your Honor.
And testing was supposed to begin on June 13, 2025. Is that right?
Yes, Your Honor.
And you didn't do any testing at all. Is that right?
I did with, Deer, I did with my probation officer, but not after that, no.
Once you got released from jail, did you do any drug testing?
I think one with my probation officer, and then I didn't do any after that.
Okay. And so as a result of that, we sent out a order to show cause, or to appear for a probation violation for a hearing on July 16, 2025, and you did not appear for that hearing, is that correct?
No, I never got any paperwork, but no, so, yes, so no, I didn't appear.
All right, I'll accept the plea. It's been given understand voluntarily and accurately. Ms. Sanford has had full knowledge of her rights. She's had competent counsel. I do have a violation of probation sentencing recommendation.
Your Honor.
Ms. Underwood, do you have that?
I do, but Your Honor, I think in this case, I would like Ms. Sanford to have the opportunity for rehab services in this case, Your Honor. I think that's extremely important. So I would ask if we need to put the sentencing out, or if that's something the court would consider at this point, because Ms. Sanford, Your Honor, needs help. Jail is going to do Ms. Sanford no good. She needs help, and I think rehab would be the most appropriate sentence she could be given.
Okay, do you know what's going on? And it says according to this, she has a suspended sentence on 3 cases with Judge Morgan. Do you know what's going on with those?
Ms. Sanford?
What is that?
What is going on with your cases with Judge Morgan?
I don't have any idea. I have not been down to see him.
Okay. Okay.
I'm assuming it's the 3 charges I have here. I don't know the other charges.
Ms. Underwood, do you want me to set a sentencing date till we know what's going on with that?
Yes.
Okay.
He's waiting for Mr. Osinger to do his, then he's doing his. I'm not sure.
Just a week or something, Your Honor.
Okay, let me go with September 26th at 8 a.m. then. Okay, so September 26th at 8 a.m., we will do the sentencing and hopefully know what is happening in district court.
Thank you.
All right. Ms. Sanford, you can let the officer with you know that you're done with court for today.
Yeah.
Okay.
Oh.
Okay, let's see, Mr. Coleman, I'm not sure where Mr. Malero went. He's apparently logged out of my Zoom session. So as soon as he gets back, I will. Oh, I'm sorry, that's you're Mr. Morris, not, I apologize.
Yes, sir.
Mr. Morris, Mr. Malero is no longer in my Zoom session. I will, we'll get back to your case as soon as he gets logged back in.
Yes, sir.
Mr. Dagger-Magosian, Mr. Nelson is here in the courtroom. Are you ready to proceed with him?
Yes, Your Honor.
Okay, Mr. Nelson, you can come forward and sit at the table here closer to the television screen. This is file 25-22150-FH People versus Milo Edwin Nelson Jr. We are here today for a pretrial conference in this case and proceedings today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, may I have the people?
Your Honor, Michael Dagger-Margosian for Mr. Nelson.
Okay, and Mr. Dagger-Margosian, I have amended information and in the file. Is Mr. Nelson entering a plea today?
Yes, Your Honor.
Okay. Has he signed an advice of rights form?
I don't believe so, but he would do so today.
Can you print one for him? And in the meantime, Mr. Dagger-Margosian, if you want to state the terms of the plea agreement, you can go ahead.
Your Honor, the court should have received a plea agreement form sent by Mr. Sneed. That form indicates that Mr. Nelson will be pleading guilty to an added count of misdemeanor larceny with the 200 to 1,000. In exchange, the original information and habituals would be dismissed. There's an agreement that over the course of probation, Mr. Nelson would satisfy the restitution amount of $1,095. There is in the plea form, there's a suspended jail sentence at the discretion of the court. And then lastly, the item says the people shall remain neutral as far as the length of probation. I've spoken with Mr. Sneed. We believe that a year of probation would make sense because really the biggest condition of probation will be this the payment of the restitution. So with all of that being said, that is and there's an agreement for no upfront jail at the time of sentencing.
I'm sorry, what was the amount of that restitution?
$1,095.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is. The only thing I would clarify is I think as to the jail sentence, it would be that if any jail is imposed, it would be suspended.
All right, I'm sorry. Mr. Nelson, the bailiff is going to hand to you an advice of rights form. Take whatever time you want to look that over, and when you're comfortable, please, if you're comfortable, please sign it. So would you raise your right hand, Mr. Nelson? Do you swear or affirm to tell the truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Milo Edwin Nelson Jr.?
Yes, Your Honor.
Mr. Nelson, have you heard the statement of your attorney and the prosecuting attorney? Is it your intention to plead guilty today to count 2 on the amended information, larceny of $200 or more, but less than $1,000?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a fine of the greater of $2,000 or 3 times the amounts taken or involved?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed it on the record here today. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger-Margosi?
Correct, Your Honor.
Is that also your understanding, Mr. Nelson?
It is, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during the trial and not have that silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Nelson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Okay.
You also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Okay.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights? Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about December 1st, 2024, in the village of Addison, County of Flannery, State of Michigan, you did commit the offense of larceny of $200 or more, but less than $1,000?
Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes, sir.
I'm sorry, I have no trouble hearing you.
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do.
Is it your own choice to plead guilty today?
It is, Your Honor.
Mr. Dagger-Margosi, do you want to establish a factual basis?
That's fine, Your Honor. Mr. Nelson, on or about December 1st of 2024, were you in the village of Addison, County of Lenawee, State of Michigan?
I was.
Okay. And on that date, on or about that date, did you take a trailer into your possession?
Yes.
Okay. And you agreed that at that time the trailer belonged to a brandy herd?
Yes.
All right. And on that date, you did not receive authorization from Brandy Herd to use that trailer or to take that trailer?
Correct.
All right. And would you agree that for purposes of the plea that the trailer, the value of the trailer was between $200 and $1,000?
Yes.
Okay. I'm satisfied, Your Honor.
Satisfied, Your Honor.
Thank you. As the court will apply with MCR 6.302 B, C, and D, Ms. McClure.
As.
Mr. Dagger.
Yes, Your Honor, it has.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Nelson has had full knowledge of his rights. He has had counsel. I would also note that he has signed and I have placed in the file an advice of rights form. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here today. I will refer this matter to the District Court Probation Office for a pre-sentence investigation and set sentencing for October 24th at 8:15 a.m.
Your Honor, I will be out of town that day. I'm sorry.
Okay, how about October 30th?
That's great. Thank you.
So October 30th at 8:15 a.m. for the sentencing. Mr. Nelson, you'll need to report to Mike McCarron in the District Court Probation Office. That's on the first floor this coming Tuesday at 8 a.m. Okay, so you are all set. Thank you.
Your Honor, we were scheduled for trial tomorrow and Friday. Obviously, can we just remove that from the?
Yeah, we will vacate those trial dates.
Thank you.
Thank you. Okay.
And Your Honor, I can cover Mr. Morris if the court wants to. Oh.
Yes, we have, Judge will say, we have Joshua. I'm sorry, Mr. Dagger, what was that you said?
I'm sorry, I am corresponding with Mr. Milaro. I can cover for Mr. Morris. He's just asking me to ask for an adjournment and to ask for a $100 bond.
All right, this is file 25-22334-FH. People versus Robert Scott Morris. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure for the people.
B.B. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Morris, covering for Mr. Milaro.
All right, and where do we stand with Mr. Morris's case today?
Well, Your Honor, as I was speaking off record, I am corresponding with Mr. Milaro. Assuming Mr. Morris is okay with the plan, I'd be asking the court for a short adjournment and to ask for a bond imposition of $100 so that Mr. Morris is getting jail credit at this time.
Okay, has he? Ms. McClure, anything that you would like to address?
No, Your Honor.
I just want to look up his case. I think he should already, well, he's got 2 bench warrants. I don't know if I can't tell from the file whether he's been seen on those or not.
I also don't show that we have a pretrial date set for him, but we may, and it just may not be reflected in our file.
Okay. So he has 2 bench warrants in this file, and I don't see any record of him being arraigned on those bench warrants. Prior to that, he had a PR bond. You know, is he incarcerated on a different case?
Well, Your Honor, I see that there are 2 district court matters that are set for contempt hearings, so that may be the case. Mr. Morris could maybe inform us more if we need it.
Okay. Mr. Morris, when were you arrested?
Not last Monday, the Monday before.
I'm sorry, I couldn't hear you.
Not last Monday, I think the Monday before.
The week before?
Yes.
Do you know if you ever saw Judge Anzalone the day after you got arrested or shortly after?
Is this a woman?
Yes.
Yes, I did see her.
Okay.
Judge, it shows that he had a bench warrant arraignment on September 8th with Judge Anzalone.
Oh, thank you. How did I miss that? Okay, so he was arraigned on these bench warrants on September 8th. There's no indication that his bond was modified on those, and so he's getting credit for any time that he's serving.
Is he, Your Honor? I mean, I see that doesn't he have a PR bond on the underlying case, and he's already been arraigned on the bench warrant?
Oh, yeah, okay, so all right, so we'll give him a $100 bond on the underlying case. The bonds on the bench warrant remain where they are. I mean, I'll give him credit for everything.
Understood. Thank you.
Okay, and I'm sorry, did we pick a date for the pretrial? Let's set that then for October 11th. I'm sorry, October 1st. Okay, I'm sorry, anything else we need to address today, Mr. Dagger-Margosi?
No, thank you, Your Honor.
Okay, Mr. Coleman, you can let Mr. Morris, you can let the officer with you know that you're done with court for today.
Thank you.
And Mr. Dagger-Margosi, do you need to speak to Mr. Coleman?
I will, but I'm wondering if the court would read the contempt allegation before I go into the room with him.
Okay, so the allegation is that Mr. Coleman failed to enter and successfully complete inpatient treatment at Dwan Farms. Defendant left treatment against staff advice on July 15, 2025. Defendant failed to reach out to pretrial services coordinator Coast upon leaving treatment to get set back up with drug testing.
Okay, and the only other question I have, Your Honor, well, two things. Which file is this on?
This is 25-22283-FH.
Okay, and the last question I have for the court is, can we double check that was court ordered? I think that was an issue that was brought up in district court, and I'm going to talk with Mr. Coleman about that.
Yeah, so his pretrial release order from June 12th, 2025 indicates that he must comply with requirements made by Darren Coast. Defendant must provide a consent to Darren Coast if he enters inpatient treatment. Defendant must report to Darren Coast today or report to inpatient treatment.
Okay, thank you. If I could be in a breakout room, please.
Yeah, 1 second. This is Judge Olsaver again. I think we're down to our last one, and that's Hezekiah Hall. Oh, is he on a different level? Oh, okay. Okay, thank you. Right.
Your Honor.
Yeah.
So I'm going to ask you, Justin Snyder, are we done with him?
He was adjourned to October 1st.
Okay. And then Demetrius McGowan. That's a Noe case. I didn't see Noe here today.
He entered a plea yesterday or the day before. It was a misdemeanor.
Misdemeanor. Okay.
Yeah.
Right. That was
Yeah.
him. Okay. I wasn't on that. What about Patrick Stevens on the last page, Judge?
He's getting adjourned. I don't know what the date is for him. We'll let you know when we have it.
Okay. I think that's it for me then, right?
Yes.
Okay. Thank you.
Thank you.
Have a good day.
Thank you, you too.
Judge, do you need me for anything else? I'm supposed to be in district court.
I don't think so. This last one is a contempt and the other one's an extradition. So I think we're all set.
Okay, thank you.
Yep, thank you.
We didn't have Dylan Scott.
No, he was actually, he's Judge Anson's case.
Oh, okay.
Hi, Rhonda. The only thing I have left is Hezekiah Hall, and we've called for him. We're just waiting for them to bring him up.
Okay. Can I ask, did you have a Candy Ostrom on the docket?
I do not believe I did. Let me check and make sure. No, she was not on the docket today.
Thank you.
Okay, this is file 25-22383-AX, People of the State of Michigan versus Hezekiah William Hall. We are here today for an extradition hearing. We are proceeding today by video conference. Sir, you are Hezekiah William Hall?
Yes, Your Honor.
Mr. Hall, this is a proceeding to determine whether you wish to waive your rights of extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender to return to that state to face a charge that's been made against you in that state. You have been charged in Williams County, Ohio, with failure to appear for a felony court hearing on August 13, 2025. We cannot, in the state of Michigan, determine the truth or falsity of the charges made against you in the state of Ohio. You do not have to waive your right of extradition. You can require that the governor of the state of Ohio make a demand upon the governor of the state of Michigan for a warrant for your extradition. You have the right to demand and procure legal counsel. If you can't afford an attorney, the court will appoint one for you at public expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That's a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand those rights?
Yeah, I got a couple things I gotta say as well whenever I can get the chance to.
Okay, do you want to be represented by an attorney?
No, I just rather talk
already-
about, I was rather talk to myself about, I was rather talk to myself.
Okay. You don't want an attorney, is that right?
No, I just rather talk to myself.
Okay. What is it that you wanted to say?
So I was just with Miss Fitzgerald yesterday. She talked to my lawyer out there in Ohio. I've been accepted into a rehab, and agent in Lenawee County also agreed to do rehab. We're just waiting for Ohio to see if they can accept, if they'll accept that. I'm out on bond there. I bonded out for $10,000 and out in Ohio. And so like when I caught a charge out here, they gave me rehab. They wanted me to go to rehab. So there's a bed available for rehab. They accepted me. I'm in the program. I'm accepted in the program. I'm on bond out there. They didn't revoke my bond, is what I'm being told. I've been talking to my bond agency. So I'm just trying to see, like I've been doing good, you know, and I'm just trying to see if they'll let me go to rehab.
Okay. So I don't have any, in this case, any ability to do anything about what this is Ohio wants to have you brought back to Ohio so that they can address the case in Ohio. And
Okay.
you can either agree and go voluntarily, or you can require a warrant be issued for your extradition to get you taken from Michigan to Ohio. That's the only thing that this case is about. Do you understand all that?
Yeah.
Okay, are you sure I can appoint an attorney for you and you can speak to her and ask any questions you might have?
Your
Yeah,
Honor,
I'll
I was
speak to her.
appointed on this case before.
Oh, you have, okay. So let me put you in a breakout room with Ms. Underwood then.
Well, no, Your Honor, I believe I spoke with Mr. Hall yesterday, and I tried to explain the same thing that you just explained to him. The problem Mr. Hall has at this time, Your Honor, is he has a felony case that I'm representing him on downstairs, where there is a preliminary examination scheduled for the 29th of this month. There is an offer where Mr. Hall can plead to an attempt, Your Honor. Mr. Hall does not want to do that. I would be more than willing to have Mr. Hall released and address his charges in Ohio and fight his charge here. I'm all for that, Your Honor, but we just have to figure out if that's what's going to happen, how it's going to be done, or what the court wants to do.
Okay, so what is his bond situation on the case that has the preliminary examination?
I do not know what his bond is on that, Your Honor. I apologize.
My bond is 51,000, but if I'm eligible, if there's a bed available for rehab, I can go to rehab. I've been accepted and there's a bed waiting for me, but I have to just make sure what Ohio will let me do. My attorney said bring this up today. The questions I just asked you, Your Honor, my Ohio lawyer told me to ask you today. That's why I asked you those questions. So I don't know what to do, to be honest. And it doesn't look like Miss Underwood knows what to do, to be honest.
Okay. Let me do this. Let me set this for Friday morning at 8:15 or 8. Let's go with 8 a.m. I'll be honest. It's a kind of a complex situation, and I'm not sure what to do right now anyway, either. But I will. I'm sorry. Go ahead, Ms. Underwood.
I will talk to Mr. Hall again, and also talk to counsel or the prosecutor on this case, and see if I can find some way to arrange this case properly, Your Honor. Thank you.
All right. So
Friday morning
at 8 a.m. And I just want to, Mr. Hall, the piece I don't get is that if you're telling me you have a bond in Ohio, but I have this bench warrant for you in Ohio, and those are inconsistent. And that's what I need to figure out.
Yeah, I don't know what's going on. Like, this all confuses me like a lot. But my bond agency told the person that bonded me out that they didn't revoke my bond, so that's why I don't understand. But all I know is that Lenawee County accepted me in a program of rehab to where I can go to rehab, and I just want Ohio and Lenawee to be on the same page. I just want to go to rehab and get help. That's it.
Do you have an attorney in Ohio?
Yeah.
What is that attorney's name? Do you know?
Ian Weber, IAN WEBER. I have his phone number as well.
Thank you.
Okay.
Do you need the phone number, Your Honor?
Give me 1 second.